Are non-compete agreements with employees enforceable? Are they worth the cost and effort? These are questions I hear often. Hi, I'm Eric Bass with Venn Law Group. I work with business owners every day on how to protect their companies from unfair competition, especially when key employees leave. To me, there are three essential things you need to know about non-compete and non-solicitation agreements to decide if they are right for your situation. Before I start, please note, laws vary from state to state. Be sure to consult with an attorney licensed in the state where your employee works to be sure what you can and can't do. Part 1. What are your obligations? You've got more than one option available. The main types of restrictions you can use are the following. First, the pure non-compete. This is the most restrictive and usually the hardest to enforce. It prevents an employee from doing similar work in a specific area for a limited time. For example, a former salesperson can't sell competing products in the state of North Carolina for 1 year after termination of employment. Second, customer non-solicitation. This one can be easier to enforce. They can work in your industry, but they can't go after your clients, or at least clients they serviced with you. Based on the previous example, the salesperson can work for a competitor after termination of employment with you, but not sell to your customers. Third, non-solicitation of employees or vendors. You can also stop a former employee from recruiting your team or trying to poach your vendors. It's all about protecting the relationships that keep your business running. Those are the three main options, but there are other tools to consider too. Confidentiality clauses, non-disparagement agreements, invention rights clauses, or even a buyout that lets the employee pay to exit the restriction. You mainly need to know that you've got options, but you need to be careful how and when to apply them. So use the ones that make the most sense for your business. Part 2. When and how to use these agreements. These types of agreements are not one size fits all. Please keep in mind the following 4 considerations. First, be selective. Don't use these on everyone. Your top salesperson? Absolutely. The janitor? Probably not. Second, customize them to the situation. Do not use generic internet forms. These agreements need to be tailored to the employee, your business, and your state's laws. Third, timing is key as well. Ideally, these agreements should be signed when someone is hired or promoted or changes jobs. Fourth, consistency matters. Apply the same policies to similarly situated employees. Inconsistency hurts morale, and you can potentially hurt you in court too. Part 3. So can you actually enforce these types of agreements? I know this isn't what most people want to hear, but the answer is complicated. Remember, only a judge can order someone to stop competing or to pay damages. And that means legal fees, time, and risk. Yes, enforcement is possible with the right agreement in the right situation, but it's not always practical. Also, it may not be practical against one particular employee, but then you have to consider what the optics of not trying enforcement against one person may mean to the rest of your remaining team. That's why we regularly advise clients that prevention is usually your best strategy. Create good incentives, mainly financial but not always, for employees to stay. Take solid steps to protect your confidential information and trade secrets. Maintain more than one relationship with key customers. and always have the right agreements ready, just in case. Being prepared in advance matters most when you face this type of unfair competition. So if you're a business owner thinking about using non-competes or non-solicits, remember, 1, you've got multiple legal tools, use them strategically. 2, timing, customization, and consistency matter. And 3, enforcement is possible, but prevention is usually smarter. If you're looking for more ways to protect your business with the right policies and agreements, contact us at Venn Law Group, and we'll do our best to help you put the right protections in place before there is a problem.